To the fifth case on this morning's docket. It's case number 111365 in the matter of Paul P. Hasty Jr.
May it please the Court, Stan Hazlitt appearing for the Disciplinary Administrator's Office. I'd like to reserve 2 minutes, Your Honor.
2 minutes is granted.
We're here as a result of a hearing that occurred on December 19th of 2013. The hearing report was filed on February 10th of 2014. The respondent appeared at the hearing with counsel, Mr. Ambrosio. At the hearing, the respondent stipulated that he had violated two rules, the rule on diligence and the rule on communication. After hearing testimony at the hearing that day, the panel found that the respondent also violated 3.4D by failing to make a diligent effort to comply with discovery requests made by opposing counsel, and 8.4D, conduct prejudicial to the administration of justice because of the respondent's failure to appear at 4 different hearings during the course of the litigation. No exceptions were filed by the respondent to the findings made by the panel. The panel recommended a 2-year suspension. They did not make a requirement or a recommendation of a requirement of a reinstatement hearing under Supreme Court Rule 219. Our recommendation was indefinite suspension, which of course does require a reinstatement hearing. Really, the appropriate discipline in this case is the only issue before the court today. The misconduct arose out of a personal injury case, a civil case, in which the respondent represented 2 of the defendants. During that representation, the panel found that the respondent failed to act diligently on multiple occasions, failed to communicate significant developments in the case to his client on 9 separate occasions, found multiple failures to comply with court orders regarding discovery, as well as requests for information and discovery by opposing counsel, and failure to attend numerous hearings in the case. As I said, we recommended indefinite suspension, and I'd like to tell you my reasoning for that recommendation, and I'd like to refer you to Disciplinary Administrators Exhibits 52, 53, and 54, which set out the previous discipline of the respondent. In 2002, the respondent was placed on diversion. That case involves similar misconduct as in the present case, failure to conduct discovery and communication with his client. In that diversion, the respondent agreed to the following, and this is in Exhibit 52 before you. The respondent shall establish and utilize a diary and docketing system which includes a mechanism by which approaching court-related deadlines and statutes of limitations are noted. The respondent shall review each of his cases at least every 60 days to determine what action needs to be taken. That was back in 2002. There was a second diversion in 2007. Which is unusual. It's permissible, but it's unusual. Rarely occurs. That was not a case similar to this case. That involved a conflict of interest. Did not involve discovery problems or communication problems. We moved to April 15th of 2010, at which time this court publicly censured the respondent. That case was very similar to the present case. There were communication issues where the respondent did not communicate significant information to his client. There were discovery issues in that the respondent did not comply with discovery requests from opposing counsel or comply with court orders. When you read that opinion, it was kind of difficult for me to understand whether or not the client had suffered significant monetary damage, although it was stated that there was potential serious injury to the client in that particular instance. In the present case, that is not what's happened. There is serious financial injury that did occur to the client as a result of what the respondent did. The respondent was also disciplined in Missouri. Actually, he was disciplined in Missouri prior to the time he was disciplined in Kansas by public reprimand. Significantly, in that case, the panel report included the following language, which was cited in the Supreme Court opinion in which the respondent was publicly censured. And I think the panel and the court obviously relied on this. Quote, the respondent was publicly censured because the respondent had, quote, taken steps to ensure that he will not repeat this misconduct. The respondent has a system in place to review documents that are not immediately matched up with a file. So again, there's the representation by the respondent that he has a system in place to avoid what's now happened a third time. In that case where the respondent was publicly censured, a minority of this court would have suspended the respondent. So twice the respondent has represented to the court and to the panels that he's put something in place that will prohibit this from happening. It has not worked. In the latest misconduct, the respondent's action resulted in substantial monetary loss to his client, inconvenience to the parties, the lawyers, and the court that was hearing the case. The respondent has had not his chance, but his chances. The panel in this case cited 4 separate ABA standards which suggest that suspension is the appropriate discipline in this case. They cited 4.42, lack of diligence causing harm, 6.22, abuse of legal process by disobeying court orders causing harm to a client, 7.2, violation of a duty owed as a professional that causes injury to a client or the legal system. And finally, the panel stated or noted that suspension is appropriate when an attorney has been reprimanded for the same or similar conduct and engages in further acts of misconduct that cause injury to a client, the profession, or the legal system. Of course, we have the 2002 diversion, which is very similar to this, and the 2010 published censure, which is very similar to this. I would submit to the court that indefinite suspension is the appropriate discipline under these circumstances for the protection of the public. I'd be happy to answer any questions that you might have.
Why is that 1 year significant? And from your earlier comments, it sounded as if you thought the 219 hearing was significant. Could you please explain why that might be?
Why the additional 1 year would be significant?
Right, and the 219 hearing.
I just think that given the magnitude of the prior misconduct, that indefinite suspension is the appropriate discipline. Of course, indefinite suspension, we don't have to talk about whether or not there's going to be a reinstatement hearing, because there is a reinstatement hearing under the rule.
So you don't think there's a real purpose to the reinstatement hearing?
I do
for
think
example, if we would, I guess the bottom line question is, if we would agree with the panel in terms of time, would it be your recommendation that we would add to that a 219 hearing?
Yes, if you deem 2 years an appropriate suspension period, or period of suspension, I do believe there should be a reinstatement hearing. I think that the respondent needs to go before a panel and explain what it is that he would do differently if he gets back into the practice than he has been doing before.
Any more questions? Thank you, counsel.
John Ambrosio on behalf of the respondent. May it please the court. There's no doubt in this case that the respondent's conduct was wrong. He missed hearings. He did not advise the client about sanctions. He didn't advise the client about what was going on in the case in terms of the failure to provide discovery. All of that happened. We agreed and stipulated to the facts prior to the hearing. We entered into that stipulation. We agreed to certain rule violations. And we are mindful of the 2 prior diversions. Obviously, it was part of the 6455 submission. And we're mindful of this court's ruling when he was publicly censured. We request public censure in this case. There are mitigating factors that have to be looked at by this court when reaching a decision. Number 1, there was loss to the client, but my client's malpractice carrier paid a substantial amount of money to that individual client.
My question on that was, and I don't know if it's in the material here, I didn't see it, but it was the $1 million policy limit, or so they just paid what they had to pay?
Correct, absolutely correct. And what you're saying is that there was additional loss of $1 million. Absolutely correct.
Okay.
Perhaps, yes, yes. He also paid out of his own pocket the $23,000 that was owed to plaintiff's counsel that the court ordered him to pay as a result of his conduct. Third, He stipulated to the facts, and we talked about this Monday when I was up here. Somebody needs to get credit. Respondents need to get credit for agreeing to the facts and agreeing to the rules violation. I think when you accept responsibility, like my client did in this case, he should be granted something. Or what's going to happen, and this is not a threat, obviously, but what's going to happen, the respondent's going to read these cases, and they're going to say, why should I stipulate to the facts? Why should I stipulate to rules violations? What I'll just do is make this into a criminal case, and we'll take a two or three day hearing, which is of course ludicrous, and we all know that. And then, Ambrosio, you're going to have to do exceptions. So the process will be longer. So by accepting responsibility, like my client did in this case, he should be given, that should be given some weight. And I think that's important for this court to look at. The panel said that the respondent was remorseful. You weren't there, but this is an experienced panel, and he was sorrowful for what he did. And it's not sorrowful because he was going to lose his license. It's not sorrowful because he got caught, like some of the respondents who come before this court are. He realized he had really blown it in this case, and he was apologetic about it. Now, they did mention during the course of the panel hearing that he seemed to explain. He was remorseful, but was trying to explain his thought process during the case, what had occurred in this case. I think it's interesting that this experienced panel suggested a 2-year suspension. It's like halfway between what I recommended and the disciplinary administrator recommended. And I think, and I can only speculate, what they were thinking is, because of the stipulations and admissions, he should be given a kudo for that. I think also the evidence developed during the hearing and in the stipulation was that this was a very, very difficult client for my client to represent. There's no question that they held back on discovery. There's no question that they didn't let him know about the GSP or give him all the information. There's no question that the terminal manager, and again, I'm not making my client into a victim. I'm not whining. With my bombast, it's hard to believe that I'd be whining, but I'm not whining about it. But he had a difficult client. Yes, he was an experienced lawyer, but he had a difficult client. And maybe what he should have done was to say, get that stuff into my office or I'm going to withdraw. Maybe he should have demanded more. He chose not to do that. And he's taken the hit because of that. We understand the respondent's duty. Mr. Hasty understands his duty to the court. He understands what has come before. He could not get the client to give him the information that was needed, and he didn't take remedial measures to make them do it. I understand all of that. He should have informed his client on everything. He should have told him about the application filed by plaintiff's counsel. He should have told him about the $23,000 sanction instead of just paying it out of his pocket. And he agrees with that, and he understands that he has a problem with that. But again, he did accept responsibility. The client has suffered. The client has been not made whole, but has been helped. This is a good lawyer, a good experienced lawyer who has made some mistakes in his practice, made some mistakes in this case, but has stood up to the plate and has accepted that responsibility. Hence, we ask for a public censure. Mr. Hasty would like to address you now, and I'm sure you're going to have plenty of questions for me.
I accept the fact that I should have advised the client that there were requests for sanctions on discovery. I told the client what had been requested and what the court had ordered. I didn't say, and if you don't, the court will do whatever. But the client never told me no, and I didn't express it that way. I did not. In hindsight, certainly I would do it differently. There were problems with scheduling. That court is a circuit. For years, I thought the judge was there every other week. I've learned in this case, I was wrong. I'm right, she's there every other week unless there's 5 Mondays in a month. And then the schedule changes. And that's why those were missed. It was our fault. We did institute a program since we learned that anything scheduled in that circuit in either county is verified by a phone call, not relying on when we were there last and counting forward by every other week. So we did it. But in any event, I thought the judge was mad at me. That was the sanctions, the reason for the sanctions, and that's the reason I paid it. I certainly understand I should have told the client, because perhaps the client would have said, well, if the judge is mad at you, we ought to get a different lawyer. I think that's right. It didn't occur to me at the time, and I didn't do it. But that's what happened in this case. I thought we were current with discovery. I wrote a letter to the adverse party and said, I think we're current with discovery. If there's anything we've missed, let me know, and there was no response. And then all these problems occurred, issues came up after I was out of the case. I produced everything they gave me in response to the discovery. When I became concerned, I did go above the manager's head, asked him to send the national safety manager from Chicago, got the expense approved. We met with the manager, went through every item of discovery where she had not been in compliance. The national safety manager and the regional safety manager, who was also there, told her. She got numerous other documents, and I produced them all. And that was everything I had the last time I was in the case. I didn't do it all right. I understand that, but that's what happened. I'm very sorry. I can't fix it. And then I was no longer in the case and couldn't fix it. So I don't know what else I can tell you. That's what I did.
My understanding of your comments today is that your failure to appear on a hearing for a motion to enforce discovery, hearing on the motion for sanctions, the pretrial conference, and the scheduling conference were all because of the way this particular circuit handled its docket?
No.
All right. Correct me, please.
Partially right. There are two judges on that circuit. Cases are not assigned on an open docket. Every case is assigned to a particular judge. 1 week, this is Judge Cook, would be in Warrensburg. The next week she'd be in Cass County. This case was in Cass. My approach had been for years when something came up, and I don't have a heavy docket in either of those outlying counties. I know when she was there last, every other week is when she's there. A hearing was set in this case. I notified plaintiff's counsel that she's not there. It's the wrong week. I got no return call. I didn't show up. I thought he had scheduled it on the wrong week. He showed up. I was wrong because there have been 5 Mondays in the month. Because when there's 5 Mondays in the month, she would be there on the 1st, the 3rd, and the 5th, and then the 1st again on the next month. That's not by rule, it's by custom. And I was just wrong. The next time it came up, I got caught on a trial docket, on a jury docket, because all the hearings in those counties are on Monday, and generally in the city, jury trials start on Monday. I was reached on a trailing docket. I notified him. I think we can file the motion. And the court granted that and set it the next week. That was wrong because the court wasn't there the next week. The plaintiff's lawyer set that on it was the 8th of some month. I don't remember which month it was. And he had made the same mistake I had made. It was reset, and we told him it was the wrong week. He appeared anyway, and that's the way it was. I did not. I thought it was the different week. And I explained that to the court. On the pretrial conference, and the reason you're getting such a long answer is because the pretrial conference is different. In Cass County, a jury trial started on Tuesday. The pretrial conference is always at 3 p.m. on Monday afternoon. When the court set the case for trial, the court sets the case for pretrial conference at 3 p.m. on the Monday afternoon before the Tuesday trial. Plaintiff in this case requested a continuance, and I don't remember why, but on a trial docket, plaintiff asked the case be taken off the docket. There was good reason, and we agreed, and the court took it off. Plaintiff appeared for that pretrial conference anyway on Monday, even though it had been set the Monday afternoon that was to be before the new trial setting. I didn't appear because the pretrial conference had been taken off. And apparently all that was taken up was that I wasn't there. So
And this was explained during the course of our hearing, and I think this is why the panel thought that we were backing up on responsibility, on accepting responsibility.
That's why I say, after that, anything in those 2 counties, we call. I don't rely on any notice. I call. I didn't know that was the system, and I was wrong. But I thought the fault was mine. That's the reason I paid the sanctions. And I thought we were current with discovery. As far as I know, we were. Now,
All right, thank
later
you.
problems were different.
Any more questions? Did either of you have any further presentation?
Do not.
All right, thank you both. You reserve 2 minutes for rebuttal.
Just a couple of quick things. Mr. Ambrosio cited the malpractice insurance payment as a mitigating factor. What the panel found in its report was that that the case, of course, was a $2.5 million verdict against the respondent's client, and his malpractice insurance paid the maximum amount, policy limits of $1 million. So there's a $1,500,000 loss. I suppose that's some mitigation, but probably not a great consequence or satisfaction to the client. With respect to the $23,000 out of the respondent's pocket to pay for the attorney's fees that the court ordered for his lack of compliance with court orders, which he didn't tell his client about, that may be another penalty or sanction, but that was brought on by his own actions. Credit for stipulating to the facts, and I appreciate that, and I understand that's part of the acknowledgement of the misconduct in which you've engaged. And in my mind, I have given him credit for stipulating to the facts. The misconduct here is very serious, obviously. As Mr. Ambrosio pointed out, and as the respondent pointed out, he brings up the specter of the lack of cooperation of his client at any point in time. Instead of just ignoring it, not going to court, not complying with court orders, he could have withdrawn from the case. Sent letters to his client. I mean, he could have gotten out of the case. There was an obvious course of action under the rules of professional conduct for him to do so. And I would conclude by saying that the panel talked about these 9 instances where he didn't communicate with his client, beginning with A, the respondent failed to inform FSI that the plaintiffs filed an amended motion for enforcement of discovery seeking to have FSI's pleading struck. He didn't tell his client about that. B, the respondent failed to inform FSI that the court issued an order on June 6th of 2011 providing FSI with 21 days to comply with discovery or FSI's pleadings would be struck. He didn't tell his client about that. I would suspect that his client would have acted completely different, maybe even terminated his services at that time if they would have known at the time that it occurred. But that didn't happen. As a result of that, their pleadings were struck. They were not allowed to cross-examine witnesses. They were not allowed to present evidence. The consequences, monetary and otherwise, were dramatic. I have no further.
Any questions? Thank you, counsel. Thank you all for your arguments this morning and this afternoon. The court will take this matter under advisement.